Hi, everyone. So today's episode of Ask the Experts, we're going to be talking about wholesaling. And we have Shawn on, who's a lawyer, and he's going to be answering all our questions. Thank you so much for coming on, Shawn.
You're
Sorry.
welcome. Thanks for having me.
Awesome. I can't wait to just get on the topic because people always have questions. I think not even in wholesaling, like if people do sales privately, I feel like that whole process is even just confusing to a lot of people. They don't know, what to do if they're going to even do it on their own, like if they're just even going to purchase the house. So I think it'll be nice to go through the whole process. So let's start off with a very simple question, and let's just start off with just what is wholesaling?
Well, sure. That's a great question to start with. So wholesaling is really the selling of a contract. It's, when we're talking about wholesaling from the real estate investor point of view, it's adding value to a number of other parties. So number one, we're locking up a deal for a property. So we're bringing some value to a seller. So we're saying, Mr. and Mrs. Seller, or the seller, you want to sell your property, I'll make you an offer for this amount. If that works for you, great. So that's the first step in wholesaling. Second step means we got to go and find a buyer for that deal. And we need to find a buyer who's willing to pay us at least a little bit more than what we offered to pay the seller. And we do that by going out to Facebook, going out to Kijiji, going out to our network, our contacts, and seeing if anyone wants to buy the deal from us for an assignment fee, for a wholesale fee. And so we would do that by executing the proper assignment agreement and charging a fee on that. And at that point, the new buyer, the assignee, becomes the buyer. And you sort of take a step back, and those two parties deal with each other. And on closing, you receive the rest of your wholesale fee. And the seller's happy, they've sold their property. The buyer's happy, they've got a deal, and they're going to do their value add process, whether it's flipping, or whether it's burying, or whether it's simply buying a turnkey property under value and refinancing, a little bit later to pull some capital out. And as the wholesaler, you've made a wholesale fee. So whether it's 5,000 or 100,000, I have a client right now that's doing a $3 million wholesale fee. So it can really range.
Wow. Yeah, and I guess it's whatever niche you decide to pick in, and probably just how good of a negotiator you are.
Well, it certainly has to do with negotiation, but in the end, there's got to be value going all three ways. So, the
Solving
sellers
everyone's
got it.
problems.
What's that?
Solving everyone's problems.
Oh, absolutely. So the seller, needs to be happy with what they're getting, and of course, that's what we want as wholesalers. We don't want to be taking advantage of people. We don't want to be sort of creating a name for ourselves where we're just going in and offering ridiculous sums for properties. We want to make sure that the seller is at least getting a decently fair offer, and that their problem is being solved.
Exactly. And Shawn, you've done a wholesale, so you can actually talk not only as the lawyer, but you can also actually talk as as doing a wholesale. So I was wondering just to hear your point of view as a wholesaler, or you done a wholesale, just, what I guess advice you'd give to people who, let's say are talking to the buyer.
Sure. Well, number one, you've got to know your numbers. You've got to be able to show that there's actual value here, right? There is a deal to be had for the buyer. So we want to be real careful about this, right? So we don't want to inflate the value of the property to the point where we're selling a deal that's not really what we say it is, right? If we want to do this more than one time, that is, right? So if we want to do this more than one time, we want to be giving fair value. So we want to show these are some comps. these are some comparable properties for current as-is value and after repair value, depending on what the strategy is. We want to have run our numbers and sort of made sure that there is a deal to be had. We want to help our buyers choose a strategy. So maybe this is a good flip project. Maybe this is a good BRRRR project. There's all sorts of different strategies that we could employ. And so we want to run those numbers in advance, and we want to be able to show our buyers, hey, this is the value you're getting. This is the after repair value expected. This is, how much we want to estimate for renovations. Here's a conservative estimate. And we also want to make sure that we're showing pictures. I like video tours. So I like pictures and video tours, really, because that eliminates a lot of the need for going through the property, and really means that, if we are going to go through the property with a potential buyer, we've got a serious person coming through, right? Mm-hmm. So we want to keep all these things in mind. We want to make sure that we're offering value, and that we're not necessarily just trying to create value for ourselves, because that's a very quick way to not be a wholesaler for too long.
Yeah, or just lose the deal. Because I feel like if you're not authentic, if you don't even show that you're helping the person solve their problem, I mean, that becomes very transparent very quickly, and they won't even look at you at all. So I feel like it's definitely knowing to solve their issues becomes such a big importance. And I think that's like communication or negotiation. I feel like I've become a person now that's kind of come hand in hand for me. I feel like now negotiation is, I used to see it as a negative thing, whereas like now it's like, it's just a way of communicating, and you're just making sure you're providing value to everyone. So now that we've spoken about both sides, now would you like to talk about how to fill out the assignment form, the Form 145?
Sure. So the Form 145 is a somewhat tricky form to fill out. We've got to be very careful with it. I've seen a deal as late as this morning where a realtor filled it out incorrectly. So I'm happy to bring people through the agreement, and I'll share my screen here, and we can take a look at here. Let me scroll all the way up to the top. So this is the standard OREA form, the Form 145, which we would use to wholesale property. So this is how we assign the agreement. So number one, we'll get our terms right? As the seller of the deal, right? And as a caveat here, as an aside, when we're wholesaling, we're never wholesaling real estate. We're actually wholesaling a contract, right? So we're selling a contract. We don't ever want to talk about selling a property or anything close to that, because we might get ourselves in trouble with the Real Estate Commission of Ontario, and sort of actually be in violation of the provincial legislation, which prohibits people from selling real estate that they don't own unless they're either a registered salesperson or a registered broker. So as an aside, make sure you're always talking about selling a deal. You're selling your assignable rights and obligations in a contract. So when we are doing that, we are the assignor, right? We are giving this contract to someone else for a fee, and that someone else is the assignee, right? So just like filling out the Form 100, the agreement of purchase and sale, the buyers at the top, the sellers at the bottom, same sort of thing here, but we're using some slightly different terms. The interest is in the real property. So it's actually in the contract for the real property. And we would fill this section out just like we filled out the agreement of purchase and sale. When we get down to purchase price, this is where I start to see people go wrong. So this purchase price is to be the total purchase price inclusive of the wholesale fee. So if we have a property locked up for $100,000 and we want to sell it for 110, we're going to write 110,000 in here. And in words here, right? We're going to go 110,000. Right. So that's our total purchase price. Then we get to the deposit. Now you see here, assignee submits. What does that mean? That means our assignee, our buyer of our deal, is submitting a deposit on this contract, right? In what I recommend my clients do is two things. The deposit should be at least 50% of the wholesale fee and at least twice as much as the deposit that you paid on the original contract. So let's suppose here we want a $5,000 deposit. So we are going to fill this out as in the following way. So this first section here is when the deposit gets put in. So is it upon acceptance? Is it with the offer? Is it at some other time? So typically I would want that on acceptance. So I would type in here upon acceptance, right? And here's where I would put in my deposit. So I want a $5,000 deposit on my wholesale assignment. And so I'm going to put 5,000 here. And where am I going to have it payable to? Well, to my lawyer. I don't recommend that people accept the deposit to themselves personally, because if the deal falls through for a reason other than the assignee's fault, so for instance, perhaps the seller can't close, perhaps the seller can't give good and marketable title. I've had that a number of times this year already, where the seller was not able to give marketable title. We don't necessarily want to be mixing up our funds with funds that were paid as a deposit and then are now owed back to the assignee. That gets a little messy. And if you happen to spend it and you got to come up with it and you don't have it, you could be in trouble. So we don't want to be going to court. We don't want to be dealing with that. We don't want to be taking that kind of risk. So what do? We put it in trust with our lawyer, right? So we go assignee, assignor's lawyer in trust. If it's me, you're writing in Shawn Quigg, Carson Law Office in trust, or Carson Law Office Professional Corporation in trust. Make sure you, for all those watching, make sure that you give me a holler before you put my name in. Make sure that I don't have a conflict. But if you have another lawyer, of course, be in touch with them, and then have your lawyer's name appear here in trust. Okay, so we'll scroll down here. The rest of this is kind of boilerplate. So we don't necessarily need to go through these terms, although I will come back to section 3 a little bit later on. So when we get down here, we're going to get to the signing and then Schedule A. Here's where, just like in the original agreement of purchase and sale, we're going to put in our conditions, right? Our terms of the deal. So, there's a number of terms that I would recommend that people put in here. So a confidentiality clause, a properly drafted confidentiality clause prohibits the assignee and the assignee's lawyer from disclosing any of the financial terms of this agreement to the original seller. We don't want that. We don't want the seller to know that we are making a fee off of this contract, even though we have every right to, and this is a completely legitimate way of doing business and offering value to people. Sellers sometimes get a little upset. So we don't necessarily want them to hurt the deal or cause any trouble. So we make the financial terms of this assignment agreement confidential, right? We don't want people or the seller to know. So we prohibit the assignee and the assignee's lawyer from communicating those details. As the assignor's lawyer, I'm going to give a notice of assignment. I'm going to tell the seller's lawyer and the new buyer's lawyer, hey, this deal's been assigned. This is the new buyer. This is the new buyer's lawyer. You guys can talk now. The terms are confidential, except for the following. And that's usually where I would put in the non-financial terms that the seller needs to know. For instance, if the seller agreed to sell the property in as-is condition, we want our new buyer to agree that they're buying the property in as-is condition for a number of reasons. We don't need to go into why. We just want to make sure that they are doing that. So I would have a term in here that they're accepting the property in as-is condition, and I would tell the seller that the buyer is accepting the property in as-is condition, etc. The last thing I would do in that notice is tell them that the new buyer, the assignee, has covenanted to perform the buyer's obligation as if they were the original buyer. That's section 3 of the agreement. I'm going to get into that a little bit later because it's a very important part. It's in fact probably the most important part of the agreement. So section A, or schedule A rather, is where we would put all of our terms that we want in. Now, one helpful point for wholesalers out there or people who are interested in getting into wholesaling, we don't ever want, unless the circumstances require, we don't ever want to sell an assignment deal conditional, right? We want our deal to be firm, and we want the buyer to tell us to go firm up the original agreement. And that's because we don't have all that much time to waste on a conditional offer, right? You might only be conditional on your original agreement of purchase and sale for a week or two. And if that's the case, you can't afford to give some potential buyer a week to go get financing. You just don't have that time, because if they back out, you've just lost a week where you couldn't sell this deal to someone else. So we want to make sure that this deal is firm. When we move on to Schedule B, this is where I really see things go astray. This is the financial part of the deal, right? This is where we set out the numbers. So let's go through this deal as we had it. So let's say we, as I mentioned earlier, we bought this property, or we locked it up for $100,000, and we put down a $1,000 deposit, and we're going to sell this deal for $110,000, right, with a $10,000 assignment fee. And as I said above, we're going to have a $5,000 deposit. So how do the numbers look? Number one, section 1 says total purchase price, including the original agreement of purchase and sale and this assignment agreement. So as we know, that's $110,000. That's $100 plus our $10,000 wholesale fee. So this is going to say this. Okay. The purchase price of the original agreement of purchase and sale is indicated in Schedule C is next. Well, we know what that is. It's $100,000. So we're going to put 100 here. Deposit paid by assignor to the seller under the original agreement of purchase and sale as indicated in Schedule C. Well, I just mentioned that we paid $1,000. So I don't know if I can put my cursor here. Maybe not. Let me just move this. Anyways, we'll call it $1,000 here. Now, what this says is it's got to be reimbursed, right? And that makes sense, because that original $1,000 is going to be credited to the purchase price. And so we're not buying it. So we're going to want to be reimbursed for that $1,000, because the assignee buyer is going to get credit for that, and they should be paying you back for it. So what I typically recommend people do is on this line here under section 3, I have them say upon final closing of original agreement of purchase and sale. So right here. So I have that go in on top of this line right here, right? Just like that. And we'll, do we have enough here? Like that. And the reason that I do that is because it makes things real simple on closing. It also means that you don't have to ask your assignee for an additional deposit, right? They're paying you $5,000. If I said upon acceptance here, they would actually have to pay $6,000. Sometimes that upsets people. They don't, they think they're only got to put up 5, and now they got to put up 6. So to make things a little bit cleaner, I recommend that people put upon final closing. So let's move on. Now, section 4, payment by assignee to assigner for this assignment agreement. Well, that's your wholesale fee, and we know that's $10,000. So we're going to put $10,000 here. Okay. Section 5, deposit paid under this assignment agreement. Well, we had it all the way up here. It says $5,000. So we're going to go all the way back down, and we're going to put $5,000 here. Balance of payment for this agreement. Now, this is where we got to do some math. So let's do the math. we're owed 10,000. We've already been paid 5. So we're owed 5 on our assignment fee. But we are also owed this 1,000 upon final closing. So this number here is going to say 6,000. Does that make sense?
Yeah.
This is where I see everyone go wrong. In fact, sometimes I see section 7. This is actually not supposed to be a section. Sometimes I see people write it, even realtors write in section 7, and it's some way of explaining how to factor in this deposit. That's really comes from a misunderstanding that this is actually a complete form and no further additions to Schedule B are actually required. We just need to fill it out correctly and understand that balance of payment for this assignment agreement includes reimbursement of the original deposit. And then our last page is going to be a Schedule C, and that's the original agreement of purchase and sale. Right? We need our buyer to know what they're getting themselves into, and we attach that as Schedule C as the Form 145 sets out a number of times. And that's how you fill out Form 145.
It's awesome. Yeah, that's very helpful, because actually it's funny that you made that comment about that the person that buys it off the wholesaler, they'll think that, oh, why am I having to pay, for example, the deposit an extra $1,000? I had that exact same issue. Actually, it's really funny. Like, you added an extra $1,000. What are you doing? And so it's just like a mission to explain it to him, and then I'm like, talk to your lawyer, talk to my lawyer, like, because they thought that they were losing. They were like having to add, they thought it was like an extra fee or something.
Yeah, which it doesn't need to be. It just comes from, just a failure to understand the basic fundamentals of this agreement. And so that's why putting upon closing, way easier, because it'll show up on a statement of adjustments. Your lawyer, as the assignee, will be able to explain it to you. And you'll know you won't be out a further amount because the purchase price got knocked down by that amount of that original deposit anyways.
Yeah, totally agree. Does anyone have any questions that they would like to ask? No? Okay. So then the next thing I'd like to ask you is then, on the purchase agreement, what do you recommend, what clauses to use in the purchase agreement for the, as the wholesaler? What should they put in there when they're, requesting to purchase a house from someone?
Yeah, great question. So a couple of things. Number one, the very first condition that should go in Schedule A explains that the balance will be paid on closing through the large value transfer system or through the lawyer's trust account. So there's a standard wording to put. It's in pretty much every agreement of purchase and sale. So make sure you've got that wording down and you have it in there. The second is we need a conditional period, right? Unless a deal is screaming good where you are guaranteed to wholesale. And like as a lawyer, I'm never going to recommend that you ever assume that. Right? So we want to have a conditional period. Now, I typically recommend people use a due diligence clause and word it very broadly so that anything can be due diligence. Financial performance of a building could be due diligence. Physical condition of the building could be due diligence. Anything can be due diligence, right? We don't want to misuse the conditions. The Court of Appeal has taken issue with that in the past. So we want to make sure that we word the due diligence condition very broadly, and we want to tie the period of due diligence to the acceptance date. So due diligence is for a period of 10 business days after final acceptance of this agreement. What else do we want to do? So we want to make the due diligence in our sole and absolute discretion. Right? We don't want the seller to have any sort of say over our due diligence. We also want to word that condition that it's for the benefit of the buyer and maybe waived or fulfilled by the buyer at any time. That's sort of a legal, I don't necessarily need to get too deep into why we want to say that, but you do want to put that in because it is for your benefit, and you don't want to necessarily be caught in some sort of litigation because you didn't put that in. Next, we want to make sure that we word it so that the condition can only be waived, or it must be waived or fulfilled by the buyer, otherwise prior to the expiry, otherwise the deal is void and the deposit is to be returned. So this way, if we ever forget to notify our seller in time, or we just don't, we can be out of the deal and not have anyone assume that because we didn't say anything, we're still in. So the reason we want that conditional period is because we need a period of time to be able to go sell the deal to someone, right? We need to create a marketing package, get it out into the Facebook groups, get it out into our network. So we want to have that due diligence conditional period. The last thing you can do, which many people are under the mistaken impression that this is mandatory, but it's not. You can put in an assignment clause, right? This deal, the buyer may assign this deal to any person or corporation, etc. Okay, that's a great clause to put in. Sometimes it causes sellers anxiety. So instead of that, you could put as the buyer, if it's me, Shawn Quigg, or his assigns. I could put that in as well if the seller didn't want an assignment agreement. But here's the thing. Any contract in this province is assignable unless there is a term prohibiting assignment. So even if you don't have an assignment agreement, an assignment condition, if you don't have a condition that prohibits assignment, the seller is going to have a tough time proving that you are not able to assign the deal. So don't fret if your seller doesn't allow you or won't sign a deal with an assignment clause. Don't fret. As long as there's not a clause that prohibits your assignment, you're going to be okay.
That's a great point. Sorry, can I just elaborate a little bit more on that?
Sure.
I thought that was a great point that you brought up, because I kind of also went through that. I mean, it was more of a signing from me to my business, but it was something that I learned because of that I thought was really interesting. And I just wanted to point out, because you did 3 different scenarios, and I just want to make sure that people understood, because you said, Shawn Quigg, or assigner, which you're talking about the first page, right? You're talking about in the first page when you're saying like who is the buyer and who is the seller. So as the buyer in that section, you'd put your name and or assignee. But again, like you said, you don't really need to put that there either, right? And then, or else, which is what you said, the standard is in the clause that a lot of people like to put that clause for assignee to assign it. Or just not have it in there. So I thought that was great that you said that, because that's also something that I thought that you always had to have one or the other, or some people even put both, as in like they'll put it in the buyer and they put a clause in there, like triple, like making sure that it gets assigned, I guess.
Yeah. So speaking of triple and making sure, perhaps now's a good time to talk about section 3 of the assignment agreement. Okay, so when I talk to clients, the thing I hear the most, the thing I get asked about the most is liability to close. What if the assignee backs out? What if something happens? Do I have to close? The answer is no. And that's because of section 3 of 145. If you have your own assignment agreement that's not the standard form, this advice doesn't necessarily apply. But if we're using the standard form, section 3 completely takes you out of the deal.
You as a wholesaler.
You as the wholesaler. I explain it like this. I don't know if I can maybe draw on a chalkboard. Let's see. I think I can. Yeah. Okay. So over here, we have our seller. Okay. So we'll move this over here. We'll call this wholesaler. And over here, we're going to have assignee buyer. And we'll put a party here and a party here. Okay. So originally, when we lock a property under contract, we put a contract between these two people, right? Okay, that's great. Then we go and as the wholesaler, we sell the deal to the assignee buyer and we enter into an assignment agreement, right? This is 145 and this is 140 or 100 rather. Form 100, agreement of purchase and sale. Okay. Section 3 does this awesome thing where it basically creates a direct relationship here. But look at this. Doesn't this look sort of like a chain link fence? That's how I describe it. It's a chain. And in contract law, we call this privity of contract. Privity of contract means only two parties to an agreement can sue each other on that agreement. And this is really important. This chain is very important. It connects the assignee buyer and the seller. In section 3 of the Form 145, the wholesale, the assignment agreement, it says that the assignee buyer, upon acceptance, assumes the rights and obligations of the original buyer, the wholesaler, and promises, in essence, promises to perform those obligations as if they are the original buyer. This is a complete elimination of the wholesaler from the deal, which is very important from a liability point of view. You no longer have the option to close. You couldn't close unless you ended this deal, right? So if we went into a mutual release here, where we go, mutual release. Once that happened, then you could close because then this chain no longer exists, right? And it's now back to you and the seller. But without this, we don't have an option. We're completely like our liability is completely limited now. We don't even have the option of closing. So I see people put in, in the wholesale agreement that the assignee buyer is fully liable. Well, that's overkill, right? You don't need that condition in there because Section 3 already says it. Here's a tip. I spoke about this on an event previously, and I tell all of my clients the exact same thing because I see this time and again, and I know why they do it. They do it to eliminate liability, but it actually could get them in trouble. So what they do is, after they sign this deal, they go back to this deal and they change the name of the buyer to this person's name. Big mistake.
Yeah.
Big mistake. Because you know what that does? It eliminates
your assignment. You would lose your assignment, wouldn't you? Your money?
Yep.
Yeah.
Yep. This is gone. Right? And now this guy's gone. So you actually have this. You have, instead of having that nice chain link where we have everything connected, we have something that looks like this. Am I drawing here?
Oh, you're in the eraser.
Let's see. Where's the color?
I think you have to go to the pencil. You're with the eraser, I think.
There. Okay. Now we have this agreement. And we've got wholesaler. Right? This is no longer tight, right? Because this now exists between these two, and you have this. So you actually aren't wholesaling anything anymore. That's a big problem. Now, I see this all the time. And generally, lawyers, who understand what's going on, they don't really, engage in a sharp practice and say, oh, actually, well, now you're not assigning anything, so there's no wholesale fee, and I'll take the deposit back too while I'm at it. But they could. And we don't want that. We certainly don't want some sharp assignee buyer doing that to us either. So don't do this. There's no need. You don't even have the right to do this once you assign the deal because you're out of the deal. You now only have the assignment agreement between you and the assignee buyer, which is great. That's how we get paid as wholesalers. But don't amend the buyer. Don't amend the buyer because you could lose your wholesale fee.
Yeah, or at least don't amend that part.
Right.
That's funny. I didn't know people did that actually.
Oh, it's very common. Very common. Experienced wholesalers do it.
Oh, yeah.
Yeah, experienced wholesalers. And it's, I understand the thought behind it, right? If I'm not on as buyer, I can't be held liable for anything. Well, you can't anyways. Section 3 prohibits it.
Mhm.
So, I mean, there's no need to do this, and you just put yourself at risk of losing your fee.
Yeah, that's a great point. And talking about amending, because then you have also, I mean, I don't know if we really want to talk about it, I guess briefly talk about it, because there are technically there's I don't know, there's the amendment form. I don't know the numbers. I'm terrible with the numbers of forms, but the amendment one, and then there's also the one to basically finalize that you're okay with the clauses if you're ready to go firm. Can you just
Yeah.
briefly talk about the two, since
Yep.
I mean, they're all kind of related with the wholesaling and private selling at the same time.
Okay, so the first agreement you're talking about is an amending agreement. So this is a contract amendment form. And the reason I don't recommend people use this form when they're just fulfilling conditions is because it requires the signature of the other party, right? Amending an agreement to remove a condition requires the other party to agree to that. But if the terms are written correctly, we can just give notice of fulfillment and we don't need their signature. It's a unilateral action. We're saying, hey, I had this condition that was for my benefit. I no longer need it. I am fulfilling it. And I'm simply giving you notice of that. That's what we want. So anytime we can use the notice of fulfillment form, that's what we want to use. If we need to change something in the original agreement of purchase and sale, we would use the amending agreement. If we need to change something in the assignment, in the assignment agreement, we would use the assignment amendment form. And there is an assignment amendment form. Now, once we've assigned the deal, that makes things a little more complicated. So I believe it's section 4 of the assignment agreement says the assignor cannot amend the original agreement of purchase and sale without the consent of the assignee. So what does that mean? If we're going to amend the agreement of purchase and sale, which we really shouldn't be doing anyways, but if we're going to, we need to get consent in writing from the assignee before we do it. So what I recommend to my clients is, if you must change it, go talk to your assignee first. And usually that's not a problem. Usually you're amending it for a reason that they want, and that's fine. But we want to get something in writing from them that says, I consent. Otherwise, the change could be void and someone could be in trouble.
Mm-hmm. Yeah, great points. So, I guess I don't know what other examples are, but I guess let's say the reason why we had to amend was the date had changed for closing. They wanted to close sooner and everyone was in agreement, so we did an amendment. What are other generic types of where you see an amendment, which, like you said, you probably don't want to amend to remove a clause or something, but are there any other situations?
Yeah, so sometimes what I see are wholesalers that will assign the deal. So let's go back to my example, right? So I bought the deal for 100 and I sold it for 110. And then I go back to the seller and say, you know what? I can't buy this at 100. I can buy this at 97. And if we do that correctly, and we have conditions in our wholesale agreement that allow for this, then that jumps our wholesale fee by $3,000. So we would need to, number one, have our wholesale agreement written properly, which permits us to do this without needing the consent of the assignee, because we already have it in the terms. And then we would need to go and amend the original agreement of purchase and sale to change the purchase price from 100 to 97. Then we need to go and amend the wholesale deal to reflect the change in value and the fact that the assignment fee went up because the price went down. So our our assignee still pays 110, but instead of paying 100 to the seller and 10 to me, they now pay 97 to the seller and 13 to me.
Oh yeah, good. Yeah, that's a good example. So, okay, so we went through, actually, did we go through all the forms? We went through yeah, and you even went, I didn't know there was actually an assignment or the assignment amendment. I didn't know that there was an assignment
Yeah,
amendment.
I don't know the number of it offhand. I've only ever seen it, once or twice. Usually I see people just scratch out what they want to scratch out with initials for an amendment.
Mhm.
But you can use, that's fine. You can also use the assignment amendment form as well.
Yeah, that's good to know. I didn't know about that. So are there any questions here from anyone? Any questions? No, I think we're good now. Uh, so, um, so for when it comes to wholesaling, what is the process? I mean, obviously you're going to talk us specifically in, where you work at Carson Law. What is the process like in the back end? Like, what do you guys do to make sure that this is all taken care of? Because I know that
Yeah.
in this case, there's in general, or even you can talk about if there is other situations, but normally in this case, you'd have three lawyers, right? So as the dealing with just the wholesale part, what are you trying to make sure that your, customer is making sure that everything's good for them?
Mm-hmm. Yeah. Well, great question. So number one, once you have a firm assignment deal signed and ready to go, you're going to send me an email and you're going to you're going to attach the original agreement of purchase and sale and the assignment agreement. And you're say, hey, can you act for me on this assignment? Which, pending a conflict, I'd be happy to do. So what I'm going to do is I'm going to get a file open. And, wholesalers move very quickly. Unfortunately, we can't move as fast because if I do move too fast, the Law Society comes and tells me to slow down. So what I do is I get a file open. At the same time, I'm going to give you my banking instructions, which you can give to your buyer, right? So that $5,000 deposit on this deal that we've been talking about, that would go into my firm's trust account. So you're going to give those instructions to the buyer. And you're going to say, hey, put the 5,000 into my lawyer's trust account. Great. So when they do that, they need to send you proof of the instrument, right? So usually it happens in one of two ways. Number one, the bank draft gets produced and directly deposited into the trust account, or a wire is made. Either way, I need pictures of the draft or the wire confirmation. And if there's a deposit receipt or slip, I need that too. That way I can help my bookkeeping people keep up with the Law Society's record keeping regulations. So you send me those pictures, right? Your buyer's going to send them to you, or they might send them directly to me. Great. Okay, that's step one. Once we have that deposit in place, perfect. We sit on the deal until maybe a week or two in advance. And at that point, we prepare a couple of documents. Number one, a direction regarding funds. We say, hey, assignee buyer, you're going to submit your funds to my firm's trust account. Great. You sign that. I send it to the assignee's lawyer. Great. I also send a statement of adjustments. In this case, just like that Schedule B, it's going to look very similar, right? $10,000 wholesale fee minus a $5,000 deposit plus a $1,000 reimbursement for the deposit I paid on the original agreement equals $6,000 owing to Carson Law Office Professional Corporation in Trust. And that will complete the deal. Then I send that as well to the assignee's lawyer. And on closing, I wait and I check in. I say, hey, how's this deal going? Did it close? Is it going to close? Etc. Once I get confirmation that it's been closed, the wire for the $6,000 is to be released by the assignee's lawyer to me, shows up in my trust account. Then I prepare a wire to the wholesaler. Here you go. And of course, there's a legal fee, so we would take that off the assignment fee and send the rest.
Oh, awesome. So yeah, so I guess for the wholesale part, it's very simple. You don't really need to do any checks on the buyer because I like when you're purchasing a house, I know there's a lot more checks that you have to do. So in the wholesale, there isn't really that many checks, I guess, that you have to do.
No, because we're not buying anything.
Mm-hmm.
We're actually selling a contract.
Mm-hmm.
And so I don't have to search title. I don't have to requisition, whether property taxes have been paid. That's not for me to do. That's for the buyer to do. the assignee. I'm simply selling a contract, and as long as it's signed and duly executed, there's no checks to be done.
Mm-hmm.
So there's nothing to research. It's simply make sure logistically that the terms of the assignment agreement are complied with.
Oh, that's great. And I guess then that's why some people use the same lawyer for, I think is what, the seller and the wholesaler? Or can you even do it the other way, the wholesaler and the buyer? I know that sometimes some people do just have two lawyers and then the wholesaler uses one or the other. I can't remember. Is that true?
Yeah, so you can have lawyers from the same firm represent multiple people in a transaction, but we got to make sure that we are all consenting to that. And we also, on the lawyer's side, need to make sure that we keep our client's information separate from the other lawyer so that it remains confidential and that we can each independently represent our client in the best way, right? So we make sure everyone's represented and protected and that people get the money that they're entitled to, and we keep our confidential information separate. So that can mean a number of ways, right? So at Carson, for instance, oftentimes we see our wholesaler clients have me or Ryan represent them. And if their buyer is having trouble with their lawyer, or maybe their lawyer doesn't understand wholesale deals, we have the other represent the buyer. And then Ryan keeps his file separate and I keep my file separate. And Ryan and I talk only as if we were from different firms on that particular deal. If I'm representing the wholesaler, I'm sending the statement of adjustments to Ryan. And I'm saying, hey, Ryan, your client owes me $6,000 on closing. And then on closing, we're not wiring to our own trust account. That's simply an accounting exercise, right? Move the amount from one ledger to another, and then we release the wire to the client. So totally possible to represent multiple parties in a transaction. Just has to be done properly in accordance with the Law Society's rules, and everyone's got to be, most importantly, consenting to that. Typically, people are okay and are consenting to that because it's a lot easier when people are in the same firm.
Mm-hmm. Makes sense. Thank you so much for all the information. I thought you provided a lot of value, and it was really good to go through the forms because, like you said, not a lot of people even know how to fill out the forms or miss important things, or even like the clause where adding that assignee clause where you don't even need it. And you're right, it kind of adds less stress because someone will always question. I feel like people do question that assignment clause. So really great point.
Well, thank you for having me.
Yeah, thank you so much. And if you want to give your contact information for anyone if they want to contact you.
Sure. Best way to reach me at the firm is by email, Shawn, SHAWN, @carsonlaw.ca. You can also find me on the social medias, Facebook, Instagram, personally at SP Quigg, or I'm the REI lawyer. So you can find me there. You can interact with me on Messenger or with an Instagram message. I'm happy to chat. So we can always set up a time to have a discovery call, see if I might be the right fit for you as a lawyer. I'd be happy to chat with anyone who has any questions or who wants to get some help on a wholesale deal.
Awesome, great. Thank you so much. You provided a lot of value. And there's a comment also saying thank you. You liked the meeting. So
oh, Sudhir, thank you.
Yeah, so thank you so much. And thank you everyone for coming and listening to this. And I hope you all got value also. Thank you so much, everyone. Bye, everyone.
Bye.